Putting an asset into your living trust and connecting it to your estate plan are not the same thing. Listen, some assets should be retitled and should pass through a beneficiary designation, and others can create tax or insurance or lending problems if you change the ownership. Let me show you how to handle 7 common assets correctly. All right, let's get started. All right, so the first asset I want to talk about is a major asset that most of us hold, and that is a 401k or IRA or some other type of plan that is a tax-deferred account. Now, you're never going to change the ownership on a tax-deferred account over to your living trust. You just can't do that, right? It's always going to be maintained with an individual as the, we'll call it owner or essentially beneficiary of that account. Now, with retirement accounts, here's what you want to do. If you're married, you want to name your spouse as the beneficiary of your retirement account. And the reason you're going to do this is that when you pass, then your spouse can roll that in to their own account and continue the tax-deferred nature of those funds for your spouse's lifetime. Now, obviously, things come up where possibly you don't have a spouse or you have separate assets and you brought in a large IRA to the marriage and you don't necessarily want that to go to your spouse. So what do we do in those situations where you don't have a spouse, you have separate assets, or your spouse is no longer living? Well, that's when it gets interesting. Now, in those situations, you're going to want to name a beneficiary. Typically, it's going to be someone's children as what we refer to as the contingent beneficiary. If you're married, or if you're not married, or you have the other issues I brought up, maybe it's your primary beneficiary. But here's what you need to ask yourself. Am I comfortable leaving them this retirement account today? Because you could pass away tomorrow. And if the answer to that is no, then you may want to consider naming your trust as either the primary beneficiary or contingent beneficiary on your policy. Now, why is that? You see, if you're not comfortable leaving them the asset right away, then by using the trust, you're able to maintain some control for at least another 10 years. You see, what happened with the Secure Act that was passed, they changed the time frame in which you have to distribute out retirement assets to your beneficiaries other than a spouse. You have to do this within 10 years. And so here's where a trust can help you in this scenario. So if I have a child, I'm concerned about maybe their spouse, their marital situation, creditors. I might be concerned that the child is irresponsible or they're possibly a minor. Maybe they have special needs. Okay, whatever that is in your life, if you want to have control over those distributions, a living trust can do that for you if you name it as the beneficiary. Now, you have to be careful here. You see, if you screw this up and your trust is not set up properly, then what will happen is immediately upon the trust receipt, the certain types of accounts will not be created and will immediately pass through and be taxable upon the trust receipt. You can still have the control over the assets, meaning your successor trustee could control when the assets are being distributed out to the beneficiaries, but you're giving up that 10-year distribution framework that I talked about earlier. So here's what you need to do. You need to review your living trust to see if it provides retirement trust provisions, meaning that the funds can be paid into the trust has the retirement trust provisions built into it where it will distribute out the assets over the 10-year period. This gives you or your estate more control over those assets and allows those beneficiaries to get past possibly some of the hurdles they currently face in their lives and mature into the money. So this is a big one for a lot of people, and it's something you want to make sure you get right, because what could go wrong here, of course, is your account could be inadvertently liquidated. You're going to lose the tax-deferred distribution of rolling funds over. Funds can be immediately distributed to beneficiaries, and maybe even the wrong beneficiaries gain access to the assets. So we want to make sure we're getting this one right. Now, the second asset that a lot of people have is a health savings account. Now, the health savings account is sometimes referred to as another retirement account, because if you're not spending on health related things, the money continues to grow in that tax-deferred state. Now, here's the thing about an HSA. Again, like the retirement plans, you can't make your trust the owner. It's limited to an individual. But unlike a living trust, if you want to maintain that tax-deferred status of the HSA when you've passed away, the only option you have is to name your spouse as a beneficiary on that account. All right, that's the only possible way you have there. So if you don't have a spouse, okay, then your designated beneficiary at that point in time should be your living trust. So why would I say that? Well, for the same reasons I talked about earlier that I don't need to repeat. You've got children, beneficiaries that you're concerned about. By naming the trust as the beneficiary, then whatever provisions you set up inside of your living trust about when they're to receive the funds, what they have to do to receive the funds, then that's going to apply to these funds that the trust receives. Yes, they're going to be taxable, but there's nothing you can do about that because that's the way the trust or the HSA is set up. Okay, annuities. Now, annuities, well, you can't change anything with an annuity until you've reviewed the contract. Now, a revocable trust could possibly be the owner of an annuity without destroying its tax-deferred treatment. When the trust, of course, is acting for the beneficiary or for the owner of the annuity. But that doesn't mean every contract or trust arrangement will handle the transfer the same way. You see, an irrevocable or non-grantor trust that introduces much greater risks. You see, federal law removes tax deferral when an annuity is owned by a non-natural person. Okay, and then there are some exceptions to this. So transferring an existing annuity contract without adequate consideration may also cause the owner to recognize gain on that contract. So what I'm saying here is that, yes, your living trust could be the beneficiary or actually could be the owner of that annuity, and that's fine. But you have to make sure that your trust is a grantor trust and it's revocable. This is the mistake people make many times is they think they have a living trust, and then when I review it, 10 times or 10% of the time, it actually is an irrevocable trust or it's a non-grantor trust. And if you transfer your annuity into it, that's going to cause serious problems. All right, should your trust be the named beneficiary then under an annuity? It can, all right? So I'm not telling you can't do this where you can actually make the trust the owner. It's just that you have to look at your annuity to make sure that it's possible to do it without triggering anything that's going to cost you money or possibly invalidate that annuity. Generally speaking, we'll oftentimes name the spouse or recommend the spouse be named as the primary beneficiary. And then at that point in time, you could name your trust as the contingent beneficiary. And by doing so, again, you pick up all those benefits of the living trust, which protects your children, spendthrift and everything that I've already covered. So annuities, an important one. Okay, so that brings me to life insurance. Now, with the life insurance, you can make the owner of your policy the living trust, or you can name it as the beneficiary. You see, here's the thing about life insurance. When you're using a living trust as the owner, as the beneficiary of the policy, then when you pass on, those proceeds that are paid out under the policy will be included in your estate for estate tax purposes. If your goal is to remove life insurance from your estate, then you want to look at a different type of tool, and that is referred to as an irrevocable life insurance trust. And generally speaking, we are only looking to use that type of tool when you have an estate tax issue, when you factor in the proceeds that come from your life insurance. So, what does this mean then with life insurance? By changing the ownership or the designated beneficiary to your living trust, even if you're married, doesn't matter here. We're not concerned about deferring future gain on those proceeds because life insurance by its very nature is going to be income tax free when it's paid out upon the insured's passing. But what you're doing now by naming the trust as the beneficiary is you're picking up on that control that your estate's going to have over the funds like I talked about earlier. One of the mistakes that I see many times with people is that they'll have this trust owning all their assets and they're all built up in there and they have all these provisions to ensure that they pass on to their children in a responsible way. Maybe they're deferring out distribution until their final distribution at the age of 50. But then they have this life insurance policy of $2 million on their life, and it pays out to them immediately upon their passing because they're listed as the contingent beneficiary. You see, what happens many times is when people set up a living trust, they don't think about those life insurance policies that they have, and they don't go back and review the beneficiary designations. It's okay if your spouse is named as the beneficiary, but I would put my trust on there as the contingent beneficiary because your trust should control the distribution, especially of cash like this. So if you've got an estate set up where you're restricting ownership or your kids' access to the funds right away or your beneficiary's access, definitely want to make sure that the living trust is named as a beneficiary of that policy. That's critical. Okay. Now, the fifth one, cars, boats, and other vehicles. Should the living trust own it? Now, there's a lot of people that talk about these types of assets, or I wouldn't even call them assets, but things that you own. You know, a living trust can own it. You're legally able to place your vehicle's title in the name of your trust. However, it's not something that I typically recommend. And here's why. Right? You have titling issues to transfer it over, and sometimes that can cost you money. You have insurance, then it needs to be changed. You have financing if you don't own the car outright. So these problems right here in trying to transfer either the registered owner or the legal owner over to a trust creates friction and complication. And so what I feel that is the best way to do this when you have vehicles is not transfer them over to your trust, right? A lot of states have what is called a transfer on death vehicle title, okay? Or other states provide a more simplified process for transferring vehicles after death. And it's just a statement in the trust or personal property memorandum that expresses how you want those vehicles handled upon your passing. That to me is the best way to deal with vehicles, because what has come up many times in my practice, I've had people tell me, well, I would like to have this S-Class Mercedes to be transferred to my son upon our joint passing, after the survivor has passed. And I often ask them, well, do you plan to have that S-Class when you pass away? And people then take a pause and they think, oh, I didn't think about that. I mean, you may decide you no longer want to drive an S-Class Mercedes. You're feeling like driving a Ferrari now as you get up to 80 years of age because you want that extra speed in your life. Who knows? But the fact of the matter is that by specifying and transferring title to a vehicle that you may no longer own in your trust, I think is a waste of time. And it's better to handle it through a personal property memorandum, and then your successor trustee can transfer the title after you've passed away. Okay, the sixth one, S corporation stock. You know, a lot of small businesses are set up as S corporations, and that's great. I understand the benefit of doing that. However, how does that play into your estate plan? Now, I've reviewed many living trusts before where people have an S corporation and they've transferred their S corporation into their living trust. And I ask them, well, why did they do this? Well, obviously, they want to make sure that their business passes to their beneficiaries. Maybe it's their spouse or their children after they've passed away. Now, it's okay to transfer your S corporation to your living trust and allow your living trust to control it, but here's the thing you need to understand. If you make your living trust the owner of your S corporation, when you pass, you need to ensure that you have qualified S corporation trust provisions in your trust. Otherwise, it's going to jeopardize that tax status. And what can occur is that your S corporation could then possibly be converted to a C corporation upon your passing. So what you're looking for there, if you're dealing with a living trust and you haven't worked through Anderson, you're working through your local attorney, make sure you have what is referred to as QSST and ESBTs inside of your living trust to account for that S corporation stock or interest in, say it's an LLC, tax as an S corporation. You see, if your attorney does not understand what those terms refer to, then that tells you they're probably not the best one to ensure that that S corporation is going to maintain its S corporation tax status after you've passed away. Now, one other thing that I want to bring up about businesses that isn't really related to ownership, but I think it's important to mention. So recently I was working with a client and we were discussing their business. Now they had a very specific type of business. It was in an interesting niche. And I asked them, I said, hey, when you pass on, your trustee, the person you've nominated to handle your estate, how familiar are they with running this type of business? The guy said, well, not at all. I just trust them to make sure they're going to distribute out the assets appropriately. Well, here's the problem. You see, if you have a business, okay, in your living trust, you should nominate a separate trustee just to deal with that business, because the last thing you want to see happen is someone who's not experienced in running that business coming in and destroying value. Because a lot of small business owners, they build up these businesses, they become cash cows for them in their retirement years, and they think they're going to pass this on to their children or their beneficiaries are going to benefit from that. But then a successor trustee steps in without their requisite business knowledge. Maybe they don't hire the right people. They think they can do it on their own, and then that business value is eroded over time. So be thinking about that if you have your own business, who you want to handle that when you're no longer here. All right, the seventh one, mortgage, jointly owned, or contract restricted property. Okay, I would refer to this as assets you cannot transfer unilaterally. So what do you do here? The first thing you need to do, okay, when you're looking at something like this, jointly owned property, maybe you're in a partnership with someone else, as far as you have an LLC set up, or maybe you have restricted stock in a business of which you work for, or there's timeshares involved there, or you have a property that's governed under a buy-sell agreement. Anything that has these types of restrictions in it, before you do anything, you first need to make sure that that is possible to transfer that asset. Because if you cannot transfer those types of assets to your living trust, you could be setting up a situation where your other party, the other partners involved or the other people involved there, could buy your interest from you. And in many times what I've seen is they can buy your interest for what you originally acquired it for. And so you got to be very careful with those assets, that you understand how they can be transferred. Now, a lot of times transferring into a grantor trust or a living trust is permitted under many of these arrangements. But again, you want to make sure you're not putting yourself into a situation where you've diminished the value of that asset because you've made an improper transfer. And if it's not done right, I mean, it's going to end up in probate and it'll never be in your living trust. Okay, so what does all this mean? All right, it comes down to this, okay? Assets, transferring in or renaming the trust as the owner, it's possible with certain types of assets. With other types of assets, what you're going to do is you're going to keep it where it is and you're just going to coordinate the beneficiary designation to make your living trust the beneficiary. More importantly, with other types of assets, you don't do anything until you've read the governing documents to make sure it's possible. You see, a properly funded living trust does not necessarily own every asset. And that's a mistake that a lot of people make when they come to funding their living trust. What it means is this. It means every asset has been intentionally coordinated with your estate plan through ownership, through beneficiary designations, or an agreement governing what happens at death. That is extremely important. I hope you got that out of this video. And listen, if you'd like to set up a strategy session with someone in my office to discuss your estate plan, go into the show notes for this video, and I have a link there where you can set up a free strategy session to talk about your estate plan. Take care, and I wish you the very best with your investing.